Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. Late in the afternoon of the 24th of March, 2025, the court in Ada County released certain documents in the motions in limine briefings, one of which is dated March 21st, 2025. It is entitled State's Reply to Defendant's Objections to State's Motion in Limine regarding alibi, and just an overview as to how the briefings work. These are motions in limine. This is where the state and the defense are seeking pre-trial rulings. That's what in limine means, on certain legal issues that Judge Hippler, as the trier of law, may decide. It's the jury that's the trier of fact. They will determine if the state has proven its case beyond a reasonable doubt, but Judge Hippler is the trier of law. That's why you're seeing all of these in limine motions, replies, responses coming up on the docket. This reply demonstrates to us that the state is not budging an inch regarding this alibi defense. Basically, the state is saying, and has been saying since they filed their motion in limine, Mr. Kohberger either has to get up on the stand himself regarding a proposed alibi defense or kiss that alibi defense goodbye. It needs to be thrown out, Judge, is what the state is saying, because it is legally insufficient. In this reply, the state of Idaho is saying the defendant's objection response to the state's motion, that's the original in limine motion, offers nothing new or substantively different. In fact, defendant appears to now acknowledge that he does not have any witnesses potentially other than himself to establish where the defendant was at the time of the, as required by Idaho Code 19519 and ICR, that's the rule 12.1, partial corroboration, this is underlined, does not cover the time alleged in the state's charging documents or any affidavit in support of searching and seizing Mr. Kohberger's person or property. And citing to defendant's objection at page 2, emphasis added. That means the state is underlining what the defense's filing said here. That's what emphasis added means. State goes on, at best, the witness mentioned by the defendant, Cy Ray, can only testify generally to his opinion about where the defendant was during the early morning of November 13th, 2022. Based on the evidence, we know for a fact that cellular analysis cannot show where the defendant was, quote, at the time of the alleged offense, and, quote, as required by the applicable statute and court rule, because the defendant's cell phone was turned off during the time. And also, another issue that we have been concerned about regarding this alibi defense or the partial corroboration is Mr. Ray is not a person with firsthand knowledge like you usually see in traditional alibi defenses, who could come forward, say, yes, I was the defendant's orthopedic surgeon and he was laid up in the hospital following back surgery on the date and the time that these crimes occurred. I can testify to that of my own knowledge because I personally treated the defendant at that time. Cy Ray does not have personal knowledge. He's endeavoring to come in and to testify based on technology, which doesn't negate his ability to testify as to CSL, other types of matters Mr. Kohberger is raising here, but he does not have firsthand knowledge. And the state is driving home the point that this technology, cellular analysis, can't pinpoint him with specificity, and also at the time of the alleged offense, the state's saying that it's turned off. The defense has another opinion. It was not turned off. But this is what they're alleging here. Based on the above and the extensive history of repeated attempts to get the defendant to comply with the disclosure requirements under the law cited here, the court should enter an order prohibiting the defendant from presenting any evidence other from the defendant himself, whether by direct or cross-examination in support of any claimed alibi regarding the specific place or places at which the defendant claims to have been at the time of the alleged offense, as required by the reference statute and court rule and as directed by the Honorable John Judge's February 23rd, 2024, quote, order setting deadline and hearing, and as discussed in the state's April 24th, 2024 response to notice of defendant's supplemental response to state's alibi. And this is signed by Mr. Thompson, March 21st, 2025. He also served the original discovery and alibi demand in 2023 when the matter was in Latah County. That's how long the battles have gone on regarding this alibi defense. So in summary, the state's basically saying, Mr. Kohberger, you need to take the stand if you want to give testimony in support of your alleged alibi, or the alibi defense needs to be thrown out the window. This is Kathy. Thank you very much for joining us here today.